A Supreme Court ruling just shook the gun law world, and the shock hit state and local rules the same day. Pause. If you think this was just about one bad guy in one federal case, you could miss the part that affects your town, your permit, and your next carry decision. Quick question before we continue. Are you subscribed? Because what I'm about to reveal could keep you from trusting the wrong internet rumor and making a very expensive mistake. Hit that button now, because gun law changes fast, and the people who wait to learn about them usually learn the hard way. Here's what just happened. The case was United States versus Rahimi. The vote was 8-1. And no, the court did not say every gun law is now dead. It also did not say local governments can do whatever they want. What the court did was even bigger in a quieter way. It told lower courts how to read gun laws after Bruen, and that matters instantly in every fight over state, county, and city rules. Let me break this down for you in plain English. In 2022, the Supreme Court decided Bruen. That case said the Second Amendment protects carrying a handgun outside the home for self-defense. It also said governments cannot defend a gun law by just saying, "This seems like a good idea." They have to show a real historical tradition of similar gun regulations. That sounded simple. In real life, it turned into chaos. Lower courts started asking hard questions. Can states ban carry in parks, on buses, in restaurants, at banks, on private property open to the public? Can they ban certain people from having guns? Can they make entire neighborhoods feel like one giant sensitive place, which basically means a place where carry is banned? Some courts went one direction, some went the other way. And suddenly, whether a law lived or died depended a lot on which courtroom you were standing in. Then Rahimi arrived. Rahimi was under a domestic violence restraining order. A court had already found he posed a credible threat to another person's safety. Federal law says people in that situation cannot possess guns while that order is in effect. The Fifth Circuit struck that law down. Then the Supreme Court reversed that decision, 8-1. Now here's the part nobody's talking about enough. The biggest impact was not just the result, it was the method. The court said judges do not need to find a perfect old law from 1791 that matches today's law word for word. The government does not need a historical twin. It needs a good historical match. In other words, the question is not, did they have this exact statute back then? The question is, did they have rules built on a similar principle for a similar reason? That is a huge deal, because if courts demanded an exact twin, modern gun law would be almost impossible to judge, honestly. Back then, they had muskets, not today's carry systems, permitting databases, public transit networks, or sprawling city zoning maps. The court said the Constitution is not trapped in amber. That means frozen in time. It means judges have to look for the core principle, not just the old label. But here's the crazy part. The court also drew a line. It said the government cannot just wave around vague words like responsible citizens and call it a day. That matters too. So now both sides got something. Government's got a more workable test. Gun owners got a warning that courts still need real historical support, not empty slogans. If you're finding this helpful, imagine what you'll learn in my next video about the 5 words that protect you when cops ask about your gun. Subscribe so you don't miss it. I spend hours digging through these cases so you can understand them in plain English. Now let me explain why this hits local rules instantly. A lot of people hear federal case and think, okay, that's Washington. My county rule is separate. That is not how this works. The reason is McDonald versus Chicago. That Supreme Court case made the Second Amendment apply not just to the federal government, but also to state and local governments. So when the Supreme Court explains the test, every lower court reviewing a city or county gun rule has to use that test too. That means Rahimi did not automatically erase every local gun rule overnight, but it did change the battlefield overnight. Pause. That's the firebomb part. Think about states like Hawaii and Maryland after Bruen. They passed laws saying in different ways that even licensed carry holders could not bring handguns into many places. One of the biggest fights is over private property open to the public. Picture a restaurant, a grocery store, or a small shop. Some laws tried to flip the normal rule. Instead of, you may carry unless the owner says no, they moved toward, you may not carry unless the owner clearly says yes. That sounds small until you imagine real life. Here's a hypothetical example to explain this. Let's say you have a valid carry permit. You stop for gas, walk into a sandwich shop, and then head into a pharmacy. No metal detector, no warning from staff, no obvious sign. Under a rule like that, you might be breaking the law just because the owner never gave express permission. That is why people call it a trap. And that is exactly why the Supreme Court's guidance matters so much. Courts now have to ask, is this kind of rule really supported by historical tradition? Is it similar enough to old rules that limited guns for the same reason? Or is it just a modern workaround designed to gut public carry without saying so directly? Now, this is where it gets interesting. On January 20th, 2026, the Supreme Court heard arguments in Wolford versus Lopez, a case out of Hawaii about this very issue. A lot of the justices sounded skeptical of the state's private property default ban. On that same day, a federal appeals court in a Maryland case said Maryland's private property rule was unconstitutional. Why? Because the court said it targeted gun owners, not property owners, and pushed the sensitive places idea too far. That is why I keep saying local rules feel this instantly. The Rahimi decision gave lower courts fresh marching orders. Then the pending carry location cases started moving under that updated map. Now, quick legal note, this is educational information, not legal advice. Always consult an attorney for your specific situation. Here's what most people get wrong. They think one Supreme Court case gives a simple yes or no answer to every gun rule. It doesn't. Gun law usually changes in layers. First, the Supreme Court sets the test, then lower courts apply it to schools, parks, transit, bars, government buildings, age limits, restraining orders, drug user bans, and private property rules. So the real danger is not just ignorance of one ruling. The real danger is assuming the law is settled when it is still moving. Imagine you're at a traffic stop and you tell the officer, "I'm good. The Supreme Court struck all that stuff down." That could be a disaster, because maybe your state private property rule is still on the books. Maybe your local sensitive place rule is being challenged but not blocked yet. Maybe your permit is valid, but the location you entered is still restricted under current state law until a court says otherwise. Don't make this mistake. Never confuse this law may be unconstitutional with this law is gone today. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the gun owners who get these updates first. Click subscribe, because the next court opinion could change what's legal in your area before the evening news even catches up. So what should you actually do with this information? First, understand the big rule. Rahimi says governments can disarm a person who has been found by a court to pose a credible threat to someone's physical safety, at least temporarily. That part is real, and the court upheld it. Second, understand the bigger ripple effect. Rahimi also tells lower courts not to demand an identical founding-era law. They must look for a relevant historical analogy. That makes it easier for some gun laws to survive than some people expected after Bruen. Third, understand the limit. The government still needs more than vibes. It still needs history, tradition, and a real fit between the old principle and the new law. Courts are not supposed to rubber stamp everything with a public safety label. Fourth, pay close attention to where cases. Bruen opened the door to public carry. Rahimi clarified the method. Now the next huge battle is where licensed people can carry and whether states can turn huge parts of daily life into no-carry zones. That is why Wolford matters. That is why local ordinances matter. That is why your city council matters more than many gun owners realize. Fifth, keep your paperwork and habits clean. If you carry, know your permit status. Know your state's current restricted locations. Check whether signs carry force of law where you live. Know whether private property defaults to allowed carry or forbidden carry. And if you are under any court order, do not guess. Get legal advice fast. But wait, there's something even more important. This case also shows the court is separating different gun law questions into categories. One category is who can have guns. That includes restraining orders, felony convictions, unlawful drug use, and age-based limits. Another category is where guns can be carried. That includes parks, transit, schools, bars, polling places, healthcare sites, and private property open to the public. Another category is what arms are protected. That includes fights over magazine limits, semi-automatic rifle bans, and other weapon-specific laws. Why does that matter to you? Because a win in one category does not automatically mean a win in the others. A person might hear, Rahimi was a loss for gun rights, or Rahimi was no big deal. Both are lazy takes. The truth is more serious. Rahimi changed the legal language that judges will use in all three areas, even though the case itself was about one category. This is the part that shocked me. Some people still think the biggest threat is the law you can see, but often it's the rule hidden inside the test. Change the test and you change the future cases. That's what happened here. So if your town passes a new carry restriction tomorrow, the lawyers challenging it will be arguing through Bruen and Rahimi. If your state defends a new sensitive place ban, it will be using Bruen and Rahimi. If the Supreme Court decides Wolford by late June 2026, that ruling could sharpen the local carry map even more. And here's one more warning. Do not rely on headlines alone. A headline might scream, Supreme Court upholds gun ban, and leave out that the case was narrow and temporary. Another headline might scream, Court guts local control, and leave out that the actual ruling only changed the test. Headlines sell emotion. Court opinions control your rights. This information could literally be outdated again by the time the next major carry case drops this term. Subscribe now, because my next video will break down exactly what you need to watch for before another Supreme Court ruling reshapes where you can legally carry. So here's the bottom line. The 8-1 Rahimi ruling did not wipe out every local gun rule, and it did not give governments unlimited power either. What it did do was reset the playbook for every lower court judging gun laws. And because the Second Amendment applies to state and local governments too, that new playbook matters in your neighborhood right now. Pause. If you want clear, no-spin breakdowns of the cases that affect your rights, hit subscribe and stay with this channel. I want you informed before you carry, before you travel, and before you trust some random comment online. And one final reminder, laws vary by state, facts matter. And this video is for education only, not personal legal advice.